a WikiVidi documentaries production. Don't forget to like and subscribe. Enjoy. Brett Kavanaugh. Brett Michael Kavanaugh is an American jurist serving as an Associate Justice of the Supreme Court of the United States since 2018. He previously served as a United States Circuit Judge of the United States Court of Appeals for the District of Columbia Circuit and as a staff lawyer for various offices of the U.S. government. Kavanaugh graduated from Yale University cum laude, with a degree in American history. After graduating from Yale Law School, he began his career as a law clerk and then a postgraduate fellow working under Judge Ken Starr. After Starr left the D.C. Circuit to take the position as head of the Office of Independent Counsel, Kavanaugh followed him to the OIC and assisted him with various investigations concerning President Bill Clinton, including the drafting of the Starr Report, which urged Clinton's impeachment. After the 2000 U.S. presidential election, he joined the administration as White House Staff Secretary and was a central figure in its efforts to identify and confirm judicial nominees. Kavanaugh was nominated to the U.S. Court of Appeals for the D.C. Circuit by President Bush in 2003. His confirmation hearings were contentious. They stalled for 3 years over charges of partisanship. He was ultimately confirmed to the D.C. Circuit in May 2006 after a series of negotiations between Democratic and Republican U.S. senators. A Washington Post analysis found he had the most or second most conservative voting record on the D.C. court in every policy area between 2003 and 2018. President Donald Trump nominated Kavanaugh to the Supreme Court on July 8, 2018, to fill the position vacated by retiring Justice Anthony Kennedy. Before his nomination, when Kavanaugh's name was on the short list of Supreme Court nominees, Palo Alto University professor of psychology Christine Blasey Ford contacted a Washington Post tip line with allegations that Kavanaugh had sexually assaulted her in the early 1980s while the two of them were in high school. 2 other women also accused Kavanaugh of sexual misconduct. Kavanaugh denied all the allegations, following a supplemental Senate Judiciary Committee hearing and an additional FBI investigation. The Senate confirmed Kavanaugh's nomination by a vote of 50-48 on October 6. He was sworn in later that day. Early life and education. Kavanaugh was born on February 12, 1965, in Washington, D.C., the son of Martha Gamble and Everett Edward Kavanaugh Jr. His father was an attorney and served as the president of the Cosmetic, Toiletry, and Fragrance Association for 2 decades. His mother was a history teacher at Woodson and McKinley High Schools in Washington in the 1960s and 1970s. She later earned a J.D. degree from Washington College of Law in 1978 and served as a Maryland Circuit Court judge from 1995 to 2001 in Montgomery County. Kavanaugh is of Irish Catholic descent on both sides, with his paternal great-grandfather arriving in the late 1800s from Roscommon in Ireland. His maternal Irish lineage goes back to his great-great-grandparents settling in New Jersey. Kavanaugh was raised in Bethesda, Maryland. As a teenager he attended Georgetown Preparatory School, a Catholic all-boys high school, where he was 2 years senior to future U.S. Supreme Court Justice Neil Gorsuch. He was captain of the school's basketball team, and was a wide receiver and cornerback for the school's football team. Kavanaugh was also friends with classmate Mark Judge. Both were in the same class with Maryland State Senate member Richard Madaleno. He graduated in 1983. After prep school, Kavanaugh attended Yale University, as had his paternal grandfather. Several of Kavanaugh's Yale classmates remembered him as a serious, but not showy student, who loved sports, especially basketball. He unsuccessfully tried out for the Yale Bulldogs men's basketball team, and later played for 2 years on the junior varsity team instead. He also wrote articles about basketball and other sports for the Yale Daily News, and was a member of the fraternity Delta Kappa Epsilon. He graduated from Yale in 1987 with a Bachelor of Arts cum laude. Kavanaugh then attended Yale Law School. In his Judiciary Committee testimony, Kavanaugh said he got into Yale Law School. That's the #1 law school in the country. I had no connections there. I got there by busting my tail in college. During law school he lived in a group house with future Judge James E. Boasberg, and played basketball with Professor George L. Priest and was a notes editor for the Yale Law Journal. He graduated with a Juris Doctor in 1990. Early legal career 1990-2006. Kavanaugh first worked as a law clerk for Judge Walter King Stapleton of the United States Court of Appeals for the Third Circuit. During Kavanaugh's clerkship, Stapleton wrote the majority opinion in Planned Parenthood v. Casey, in which the Third Circuit upheld many of Pennsylvania's abortion restrictions. George Priest recommended Kavanaugh to Ninth Circuit Judge Alex Kaczynski, who was regarded as a feeder judge. After clerking for Kaczynski, Kavanaugh next interviewed for a clerkship with Chief Justice William Rehnquist on the U.S. Supreme Court, but was not offered a clerkship. Kavanaugh was admitted to the Maryland Bar in 1990, and the District of Columbia Bar in 1992. In 1992, Kavanaugh then earned a one-year fellowship with the Solicitor General of the United States, Ken Starr. Kavanaugh next clerked for Supreme Court Justice Anthony Kennedy 1994, working alongside his high school classmate Neil Gorsuch and with future Judge Gary Finerman. After his Supreme Court clerkship, Kavanaugh worked until 1997 for Ken Starr again as an associate counsel in the Office of the Independent Counsel, where his colleagues included Rod Rosenstein and Alex Azar. In that capacity, he handled a number of the novel constitutional and legal issues presented during the investigation of the death of Vincent Foster, though Starr's investigation concluded that Foster had indeed committed suicide. Kavanaugh has been criticized for investing federal money and other resources into investigating partisan conspiracy theories surrounding the cause of Foster's death, from 1997 to 1998. Kavanaugh was a partner at the law firm of Kirkland & Ellis. In 1998 he rejoined Starr as an associate counselor. In Swidler and Berlin v. United States, Kavanaugh argued his first and only case before the Supreme Court. Arguing for Starr's office, Kavanaugh asked the court to disregard attorney-client privilege in relation to the investigation of Foster's death. The court rejected Kavanaugh's arguments by a vote of 6-3. Kavanaugh was a principal author of the Starr Report to Congress, released in September 1998, on the Bill Clinton-Monica Lewinsky sex scandal. The report argued on broad grounds for Clinton's impeachment. Kavanaugh had urged Starr to ask Clinton sexually graphic questions, and described Clinton as being involved in a conspiracy to obstruct justice, having disgraced his office, and lied to the American people. The report provided extensive and explicit descriptions of each of the president's sexual encounters with Lewinsky, a level of detail which the authors described as essential to the case against Clinton. In 1999, Kavanaugh rejoined the law firm of Kirkland & Ellis as a partner. While there in 2000, he was pro bono counsel of record for relatives of Elion Gonzalez, a 6-year-old rescued Cuban boy. After the boy's mother's death at sea, relatives in the U.S. wanted to keep him from returning to the care of his sole surviving parent, his father in Cuba. Kavanaugh was among a series of lawyers who unsuccessfully sought to stop efforts to repatriate Gonzalez to Cuba. The District Court, Circuit Court and Supreme Court all followed precedent, refusing to block the boy's return to his home. While at Kirkland & Ellis, Kavanaugh authored 2 amicus briefs to the Supreme Court, supporting religious activities and expressions in public places. The first, in 2000. In Santa Fe Independent School District v. Doe, argued that a student speaker at football games voted for by a majority of students should be treated as private speech in a limited public forum. The second, in Good News Club v. Milford Central School, argued that a Christian Bible instruction program should have the same after-school access to school facilities as other non-curriculum-related student groups. In December 2000, Kavanaugh joined the legal team of George W. Bush, which was trying to stop the ballot recount in Florida. After Bush became president in January 2001, Kavanaugh was hired as an associate by the White House counsel Alberto Gonzales. There, Kavanaugh worked on the Enron scandal, the successful nomination of Chief Justice John Roberts, and the unsuccessful nomination of Miguel Estrada. Starting in July 2003, he served as assistant to the president and White House staff secretary, succeeding Harriet Miers. In that position he was responsible for coordinating all documents going to and from the president. U.S. Circuit Judge 2006-2018. President George W. Bush nominated Kavanaugh to the United States Court of Appeals for the District of Columbia Circuit on July 25, 2003, but his nomination stalled in the Senate for nearly 3 years. Democratic senators accused him of being too partisan, with Senator Dick Durbin calling him the Forrest Gump of Republican politics. In 2003, the American Bar Association had rated Kavanaugh as well qualified, but after doing dozens more interviews in 2006, downgraded him as only qualified. The Senate Judiciary Committee recommended he be confirmed on a 10-8 party line vote on May 11, 2006. He was confirmed by the Senate on May 26 by a vote of 57-36, was sworn in June 1. He was the fourth judge nominated to the D.C. Circuit by Bush and confirmed. Kavanaugh began hearing cases on September 11 and had his formal investiture on September 27. In July 2007, Senators Patrick Leahy and Dick Durbin accused Kavanaugh of lying to the Judiciary Committee when he denied being involved in formulating the Bush administration's detention and interrogation policies. In 2002, Kavanaugh had told other White House lawyers that he believed Supreme Court Justice Anthony Kennedy would not approve of denying legal counsel to prisoners detained as enemy combatants. The issue re-emerged in July 2018 after Kavanaugh was nominated to the Supreme Court. Notable cases. When Kavanaugh has written an opinion and the case has been considered by the Supreme Court, that court has adopted his position 13 times while reversing his position only once. These included cases involving environmental regulations, criminal procedure, the separation of powers and extraterritorial jurisdiction and human rights abuse cases. He has been regarded as a feeder judge. Abortion. Kavanaugh ruled in favor of abortion restrictions in at least one case, Azar v. Gaza, in October 2017. Kavanaugh joined an unsigned divided panel opinion which found that the Office of Refugee Resettlement could temporarily prevent an unaccompanied alien minor in its custody from traveling to obtain an abortion. Days later, the en banc D.C. Circuit reversed that judgment, with Kavanaugh dissenting. In his dissent, Kavanaugh criticized the majority for creating a new right for unlawful immigrant minors in U.S. government detention to obtain immediate abortion on demand. The girl then obtained an abortion. In 2018, in a follow-up petition from the Solicitor General of the United States, the en banc D.C. Circuit's judgment was vacated by the U.S. Supreme Court and the girl's claim was ultimately dismissed as moot. Thus it does not serve as precedent. Affordable Care Act. In November 2011, Kavanaugh dissented when the D.C. Circuit upheld the Patient Protection and Affordable Care Act, arguing that the court lacked jurisdiction in the case. In his dissent concerning jurisdiction, he compared the individual mandate to a tax. After a unanimous panel found that the ACA did not violate the Constitution's origination clause in Cecil v. United States Department of Health and Human Services, Kavanaugh wrote a lengthy dissent from the denial of rehearing en banc. In May 2015, Kavanaugh dissented from a decision that denied an en-banc rehearing of the Priests for Life v. HHS ruling, in which the panel upheld the ACA's contraceptive mandate accommodations against Priests for Life's Religious Freedom Restoration Act claims. In Zubik v. Burwell, the Supreme Court vacated the circuit's judgment in a per curiam decision. Appointments Clause and separation of powers. In August 2008, Kavanaugh dissented when the circuit found that the Constitution's Appointments Clause did not prevent the Sarbanes-Oxley Act from creating a board whose members were not directly removable by the President. In Free Enterprise Fund v. Public Company Accounting Oversight Board, the Supreme Court reversed the circuit's judgment by a vote of 5-4. In 2015, Kavanaugh found that those directly regulated by the Consumer Financial Protection Bureau could challenge the constitutionality of its design. In October 2016, Kavanaugh wrote for a divided panel finding that the CFPB's design was unconstitutional, and made the CFPB director removable by the President of the United States. In January 2018, the en-banc D.C. Circuit reversed the judgment by a vote of 7-3, over the dissent of Kavanaugh. Environmental regulation. In 2013, Kavanaugh issued an extraordinary writ of mandamus requiring the Nuclear Regulatory Commission to process the license application of the Yucca Mountain Nuclear Waste Repository, over the dissent of Judge Merrick Garland. In April 2014, Kavanaugh dissented when the court found that Labor Secretary Tom Perez could issue workplace safety citations against SeaWorld regarding the multiple killings of its workers by Tilikum the orca. After Kavanaugh wrote for a divided panel striking down a Clean Air Act regulation, the Supreme Court reversed by a vote of 6-2 in EPA v. Homer City Generation, LP. Kavanaugh dissented from the denial of rehearing on bank of a unanimous panel opinion upholding the agency's regulation of greenhouse gas emissions, and a fractured Supreme Court reversed by a vote of 5-4 in Utility Air Regulatory Group v. Environmental Protection Agency. After Judge Kavanaugh dissented from a per curiam decision allowing the agency to disregard cost-benefit analysis, the Supreme Court reversed by a vote of 5-4 in Michigan v. EPA. Extraterritorial jurisdiction. In Doe v. ExxonMobil Corporation, Kavanaugh dissented when the circuit court allowed a lawsuit making accusations of ExxonMobil human rights violations in Indonesia to proceed, arguing in his dissent that the claims were not justiciable. Kavanaugh dissented again when the circuit court later found that the corporation could be sued under the Alien Tort Statute of 1789. First Amendment and free speech. Kavanaugh wrote for unanimous three-judge district courts when they held that the Bipartisan Campaign Reform Act could restrict soft money donations to political parties and could forbid campaign contributions by foreign citizens. Those judgments were both summarily affirmed on direct appeal by the Supreme Court. In 2014, Kavanaugh concurred in the judgment when the en-banc D.C. Circuit found that the Free Speech Clause did not forbid the government from requiring meatpackers to include a country of origin label on their products. In United States Telecom Assen v. FCC, Kavanaugh dissented when the en-banc circuit refused to rehear a rejected challenge to the net neutrality rule, writing, "Congress did not clearly authorize the FCC to issue the net neutrality rule." Fourth Amendment and civil liberties. In November 2010, Kavanaugh dissented from the denial of rehearing on bank after the circuit found that attaching a global positioning system tracking device to a vehicle violated the Fourth Amendment to the United States Constitution. The circuit's judgment was then affirmed by the Supreme Court in United States v. Jones. In February 2016, Kavanaugh dissented when the en-banc circuit refused to rehear police officers' rejected claims of qualified immunity for arresting partygoers in a vacant house. In District of Columbia v. Wesby, the Supreme Court unanimously reversed the circuit's judgment. In Clayman v. Obama, Kavanaugh concurred when the Circuit Court denied an en banc rehearing of its decision to vacate a district court order blocking the National Security Agency's warrantless bulk collection of telephony metadata. In his concurrence, Kavanaugh wrote that the metadata collection was not a search, and, even if it were, no reasonable suspicion would be required, because of the government's special need to prevent terrorist attacks. Brought to you by WikiVidi documentaries. Would you like to know more?